We have major news out of the United States Court of Appeals for the Sixth Circuit involving, ready for this, folks, drones, hunting, and the First Amendment. How does all this mix up? What on earth are we talking about? An amazing story and an amazing decision out of the Sixth Circuit dealing with Michigan's anti-drone hunting law. Yes, you heard me right. Anti-drone hunting law. Let's talk about it when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so this is an interesting case. Remember how I've explained to you, you need to understand all aspects of American constitutional law to be the smartest person in the room. You got to understand the First Amendment, the Second Amendment, the structural constitution, how the branches work, and all of this. Because you never know how this all pops up when it comes to our right to keep and bear arms. So it's a very interesting case involving Mike Yoder and a company called Drone Deer Recovery. Drone Deer Recovery, LLC, that is apparently in parts of the country that helps hunters track down deers that they have shot as part of the hunting process, whether those deers are dead or the deers may be dying. But the company Drone Deer Recovery apparently helps provide a service of deer recovery, meaning if the hunters cannot find the deer, this company supposedly goes out using aerial drones to find the dead or the dying deer, the dead or the dying game, for the hunter, identifies where it is, and allows the hunter to go take care of business from there. Well, it turns out that there is a law in the state of Michigan that prevents the use of drones in conjunction with hunting. And there was a lawsuit brought by Mike Yoder and Drone Deer Recovery, challenging this law, this Michigan state law, the drone law of Michigan, challenging this law on the grounds that it violated the plaintiff's First Amendment right to free speech. You heard me right. They did not bring a Second Amendment argument. They brought a First Amendment argument saying that the process of deploying an aerial drone, identifying using heat signatures of the dead or dying deer, and then communicating expressively that factual information back from the drone to a hunter who paid for the service, presumably, is an expressive content, a version of free speech. And because Michigan's drone law is interpreted to prevent the use of drones in the taking of game, including the taking of deer, this company, Drone Deer Recovery, was not legally allowed to use its services or sell its services in the state of Michigan because they feared running afoul of this criminal statute. So they brought a lawsuit claiming this criminal statute, the drone law, was unconstitutional under the First Amendment, that it violated the plaintiff's First Amendment rights and the ability to sell these services and communicate this information back to hunters in exchange for compensation. Well, this was first brought in federal district court, and the federal district court judge dismissed this lawsuit basically on standing grounds, claiming the plaintiffs lacked standing to bring this lawsuit, and then it was appealed to the United States Court of Appeals for the Sixth Circuit. 3 judges heard this argument and issued what's known as a per curiam decision, which means that the 3 judges all agreed on this ruling, but none of them would actually sign the opinion that was issued in their own names. It was sort of issued by the panel and not by like a particular judge using the judge's name. So what happened on the appeal to the U.S. Court of Appeals for the Sixth Circuit? Well, they basically reaffirmed the dismissal of this case, essentially saying that although they thought that the plaintiffs did indeed have standing, and as you know, standing is a prerequisite to be in federal court because under Article 3 of the United States Constitution, in order to be in federal court, the federal judge has to have what's known as a case or controversy in front of him, because if you read the text of Article 3 of the U.S. Constitution, it specifically says that federal courts have authority, they have jurisdiction to hear cases or controversies. Well, how do you know if you have a case or controversy that allows a federal judge to make a decision? One of the ways is to ensure that the plaintiff bringing the lawsuit has actual standing to challenge the law because he or she is being directly adversely impacted by the law they're challenging, and that if a court stepped in and entered a remedy in the form of, let's say, an injunction, that law would no longer injure the plaintiffs. So while the district court initially said that the plaintiffs here did not have standing, the Court of Appeals for the Sixth Circuit said, indeed, Mr. Yoder and the company Drone Deer Recovery did have standing because their business was being hurt because they wanted to conduct business of deer recovery using their aerial drone service. They wanted to recover the deer and get paid for it. They wanted to have their services available to hunters in the state of Michigan, and this particular drone law prevented them from doing so. So they were injured by virtue of the fact that the business they wanted to deploy in the state of Michigan could not do so, and that obviously hit them where it hurts most, which is their pocketbook. Straightforward argument in favor of standing, and the U.S. Court of Appeals for the Sixth Circuit agreed with that, saying, indeed, the plaintiffs here had standing to challenge the drone law. But once you have standing, that just gets you in the courthouse door. It doesn't mean you win the case. So what happened on the case? And the bottom line is this, that the plaintiffs lost this case on appeal because the U.S. Court of Appeals for the Sixth Circuit out of Michigan said that indeed the state of Michigan can continue to enforce its ban on using drones to locate downed game, such as downed deer, and doing so does not violate the First Amendment. So why did the court say that this was not a violation of the First Amendment to prevent Mike Yoder and his company Drone Deer Recovery from using drones with thermal imaging to locate downed deer after hunting and helping hunters who would presumably hire the company to find the injured animals that have run away after being shot? Well, what the court said is, to violate the First Amendment, a law has to have some sort of bias in favor of one form or content. It has to discriminate in terms of the content of the speech, let's say. So, for example, if I say guns are good, and there's a law passed that says you cannot say guns are good, you can only say guns are bad, that would be an example of a violation of the First Amendment because it means the government is picking a message that it approves of and rejecting a message it doesn't. It's basically banning messages it disagrees with, and that would violate the First Amendment. The court here said that when Michigan enacted this drone law, it did so basically not just to protect hunting rights, but also to protect, if you will, the anti-hunting messaging of the anti-hunters. Here's what the judges had to say about why this particular law was really content neutral, meaning it wasn't picking a side in the fight, and why arguably it wasn't even speech at all. Here's what the court had to say about why the legislature enacted this sort of drone law dealing with hunting issues. The court wrote, lawmakers' stated rationale for enacting the drone statute was twofold. They were concerned that persons opposed to hunting, such as those affiliated with the People for the Ethical Treatment of Animals, PETA, might use drones to disrupt or interfere with lawful hunting or fishing. They were also concerned that hunters and fishermen could use drones to aid in taking game or fish, thus violating the fair chase principles and taking away from the spirit and tradition of ethical hunting and fishing. And that's exactly right. You see how they said it's kind of like fair game? They weren't, the state of Michigan was not picking a side. The court went on to point out exactly this yet again. The drone statute is content neutral. The statute makes it a crime to take game, a term defined to include hunting, chasing, following, pursuing, and trapping or capturing animals using drones. On its face, that prohibition applies equally to hunters who want to recover downed game, anti-hunting activists who want to find injured animals to nurse them back to health, and anyone else who wants to use a drone to follow an animal. The legislative history of the drone statute confirms that the legislators enacted the law specifically to prevent drone use by both hunters and persons wishing to disrupt hunting. So that, at the end of the day, is the gist of the court's opinion as to why they found the drone law to be constitutional. Now, there were some other arguments going back and forth that we don't need to belabor the point on. I'll put a link to the opinion down below if you want to check it out yourself. But I think it's worth noting exactly what the services to be provided by this company were. I think it's quite interesting and frankly quite creative. Here's what the court had to say about the business of drone deer recovery in the context of this case. After a hunter shoots a game animal such as a deer, the animal often runs away and dies in another location. Tracking dogs and trail cameras are two ways of finding the animal. DDR, which is the company here, offers a third option, one that it says is less environmentally intrusive and more effective than dogs or trail cameras. A hunter in an area where DDR does business can use DDR's website to connect with a nearby drone operator. The drone operator then searches for the downed animal's heat signature using the drone's infrared camera and thermal imaging technology. Upon finding a heat signature, the drone operator activates the drone's camera and searchlights to identify a downed deer or the downed deer. If the drone operator determines that the animal is dead or will die by the next morning, the operator creates a global positioning system, GPS location pin, for the animal's location and sends that information to the hunter. The hunter can then find the downed animal using Google Maps or a similar application. So that's how the business worked. And there was arguments about whether or not the tracking of this information just to gather it was a First Amendment protected activity, whether or not communicating or conveying factual information about the location of a downed deer, whether or not that was First Amendment communication or not. But at the end of the day, to make a long story short, this court basically said, because this is a content neutral activity, whether or not this is speech or not doesn't really matter, because there is a long-standing tradition in Michigan to protect the natural environment, which includes game animals that could be hunted or trapped or whatnot. So again, this is a very interesting kind of case speaking to the First Amendment and guns. And that's why when I cover other types of legal cases, other than purely Second Amendment cases, it's important for you to learn about these other areas of the law, because there's a great example of how your right to keep and bear arms, which would include all lawful activities, including but not limited to the right to hunt. The right to hunt is certainly protected by the Second Amendment as I see it. I don't think there's a debate about that because it's a lawful activity. But here's an example where your right to hunt could be impacted, maybe adversely, by virtue of an anti-drone law, for better or for worse, and how the United States Constitution, the First Amendment right to free speech, can touch fingers with drone laws and by extension, your right to keep and bear arms in the form of keeping and bearing arms for the purposes of the lawful activity of hunting. Do you see all this connects up? And that's why, to make you the smartest person in the room, and why I want you all to understand how all this stuff connects up, this is a great example of how the First Amendment, constitutional law, hunting, guns, and the like all get connected up. And that's why we talk about how to understand how all this stuff interplays with each other to make you the smartest person in the room, because you need to be able to understand these other issues to defend the core right to keep and bear arms, including the right to self-defense, the right to common defense, the right to thwart tyranny, and all the other lawful purposes of having guns in this great country. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me over there on X at 4Boxes Diner. Don't forget to subscribe both to YouTube and to Rumble. I look forward to talking to all of you again real soon here at the 4Boxes Diner.
Orders up. Table 2A.